Good morning, everybody. It is 9 a.m. and we are beginning our quarterly policy meeting. I believe we have some individuals on by Zoom. And we also have many of the commission members and other individuals present. We have a lot of items to get to this morning, so I'm going to turn over to Executive Director Bergstrom, and he's going to start us off.
Great, thank you, and good morning, Judge. Good morning, everyone. As we discussed yesterday during the policy meeting, we have a lot of efforts underway, and one of the key efforts since 2014 is rebuilding the sentencing guidelines. But a critical aspect of rebuilding the sentencing guidelines is rebuilding the application for calculating the guidelines and for reporting sentences. And so sort of hand in glove with the development of the guidelines, we've been talking about and working through some of the efforts around the application. And as many of you know, we have a web-based application, a JNet-based application called SGS Web that we've used for many years and sort of rebuilt over time, but it's sort of getting near the end of service. And we've been in a process of trying to look at what the next gen SGS Web would look like. So during the past year, we've engaged with a vendor to help us to come up with an architectural design for the next generation of SGS Web. And this morning, Christy and our guests from JMT will be talking about that design, that work that they've done, which will be the starting point for moving to the build of the first phase of next gen. So with that, let me turn it to Christy, and she'll introduce Vince and Rachel, and we'll have about a 30-minute overview of the effort underway. Thank you.
Okay, well, good morning. Again, as Mark said, as we rebuild the sentencing guidelines, we also need to be rebuilding the sentencing guidelines software application to support the guidelines. And the primary reason for this is that there are foundational changes in the guidelines, as you guys know.
Hey, Christy, is your mic on?
Yeah. Hello?
There you go.
Do I just need to be closer? Okay. Sorry about that. So the primary reason, as you all know, it's that there are foundational changes in the proposed guidelines for things like how the prior record score looks and is calculated, how the offense gravity score is going to work, especially with enhancements. And so all of this is going to need to be kind of completely redesigned and reprogrammed in the application. The other reason is the current application was really built for the specific purpose of sentencing guidelines. So it's structured around the sentencing event instead of the offender, which presents a problem when we need to look at the information at the offender level for things like automatically calculating the prior record score or integrating with the parole guidelines and recommitment ranges later on. And then the last reason, as Mark just mentioned, the technology that the application was built with is getting outdated. So it's time to update it, which will also give us an opportunity to modernize and streamline the user interface and data entry processes. So as Mark mentioned, back in May, we partnered with JMT Technologies to evaluate SGS Web and propose a new architectural design for it that could support the 8th edition, and fulfill our other needs, but also be structured in a more scalable and adaptable way to handle new requirements as they arise. So with me today, I have Vince Novak and Rachel Thomas from JMT, who we've been working with very closely for the past 6 months. So when we started working with JMT, we tasked them with developing a blueprint for the future state of the SGS Web application. So we asked them to take into account kind of what our current application does today. And so there's some screenshots up there of what our current application, and kind of what we want to do in the future, and then propose a design that could achieve it. So I'm going to turn it over to Vince and Rachel to talk about our project with them, the architecture and design that they've developed for SGS Web, and their recommendations to move the rebuild process forward.
Thank you. Hopefully everybody can hear me. Very good. Yeah, again, Vince Novak with JMT Technology Group. I do want to start off by saying we really appreciate the approach that the PCS team, Christy, Mark, and the rest of the team took on this project. Been very collaborative. Too often when we enter into software design, we find we have a single stakeholder that we're talking to, which gives us a very narrow view of the user base. We try and take a very user-centric approach to everything that we design and develop at JMT Technology Group. So the process that we've had with the team here has been fantastic. It's been very collaborative. It's been very user-focused. We've had a wide range of users that we've been able to talk to as we've looked at the current application and tried to plan out what the new application should be. And in the long run, not only does that make a better software product as far as the end output from our experience, but it also is very cost effective because we now have the blueprint, as Christy mentioned, that we're going to be able to utilize, and they'll be able to take into the implementation phase and have a really clear picture and a very user-focused picture of what we're trying to build and how it can operate and how it can be more efficient for the end users over time. So it should be an excellent return on investment in our opinion from the approach that you all talk. So I'll walk through how we approached this portion of the project. We broke it into 3 separate tasks. Task 1, we started out, as I mentioned, with that very user-focused approach. We did some stakeholder meetings where we had some workshops that we went through. We talked to different users that interact with the application and tried to really understand the workflows, the business processes, and the challenges that all those users had with the current system so that we could use that to inform our design as we move forward. So we did a number of workshops, again, in person, working with the team. We documented a lot of that stakeholder research. So we developed a creative brief report that goes through all of our findings and recaps that the team can refer back to as the process continues on. And we'll talk a little bit about some of the components of that here in the next few slides. And we also looked at some of the requirements and the workflows that we had and tried to map as is workflows and to be workflows. We kind of understood, hey, this is where we are and this is where we're going when we're starting to talk about, additional AOPC integrations, for example, or, how we're going to need to think about the application from terms of 8th edition guidelines and things that need to be built in the future. The second part of our task was really developing that user experience. So thinking about the information architecture, how the new application should be laid out, how its navigation should flow. When people are coming in, what is the first screen that they see? What are the series of following user interfaces that they're going to want to use as they're working through any particular process in the application? We flowed all those things out. We started to think about the visual aspect of what the design should look like. And we talked a lot in depth on the technical side about what the new system architecture should look like. One of the key things that we wanted to try and do was really increase areas where we could have efficiencies and integrations, try to improve how, the optimization of the application and how fast and how easy it was to use, in real time. So we've made a lot of suggestion improvements to, the system architecture overall on the back end of the application that should really improve the user experience on the front side. And then the last part, we went really deep into detail, going through all those different workflows. Rachel has developed a series of mock-ups that prototypes what the user interfaces are going to look like. We kept the same stakeholders involved in that same group so that we could continually iterate through that process and think about all the key details and the steps that we had involved and continually get additional feedback, from that user group on things that were working, things that weren't. And we've already gone through a couple of iterations just in this process with the design right now to make some improvements and to really roadmap those things. So I want to highlight a few key things that we pulled out of our user experience process and our stakeholder meetings. And then Rachel will walk through some of the highlights of the visuals and what the new user interface are going to look like. So in task 1, I mentioned those stakeholder reviews that we did, those workshops that we had. This is one of the tools and tactics that we use to go through that process. It's a solution strategy blueprint. We use this a lot when we're talking about any type of redesigns where we've got an existing application. We know we want to make some improvements and some enhancements and really map out, what's what is this going to look like at the end, when we're finished and we want to really compare, the return on our investment. So this solution strategy blueprint was a tool we went through. We had all the users in a room and we talked about their challenges, figured out all their pain points. We mapped those things out and kind of categorized a lot of those things, whether they're user experience issues, maybe they're data issues, maybe they're system issues. Then we went through and looked at some of the things that we wanted to look at as far as focus areas and what we call aspirations and focus areas. So that's kind of looking at, okay, these are all the challenges that we've had. These are the things that we want to focus on. These are the priorities that we want to look at so we can kind of map out our product roadmap for how we want to develop going forward. And from that, we distilled it down to 5 guiding principles I'll talk about in just a minute, that are basically things that we're looking at to kind of keep guiding the process in the right direction. As we think through that user experience design, it all should kind of flow back to those initial ideas, right? This is where we're going. This is what we want to try and achieve with the new application. Looking through our structure here, the activities and capabilities support all those things that I just mentioned. So we start to talk about what key functionality can we incorporate in the new system, in the new design, that'll meet those goals and those objectives that we had. Finally, once everything is implemented, what measurements do we want to look at? What are the things that are kind of key performance metrics that we'll have in the end software product that we can compare back and say, okay, this is where we wanted to go. This is what we wanted to try and achieve. How do we close that loop? So that'll come later on in the implementation process, but we've defined those things now, again, to kind of help guide the requirements and the design moving forward. So of all of that, again, our creative brief has a lot of information. We got a lot of really valuable information from all the stakeholders, all the users that we talked to. But our high level guiding principles, again, we kind of distilled those down into these 5 things. The new application should be simple, elegant, and easy to use. We want to try and automate where possible. So there's a lot of data integrations that we can bring in to increase efficiencies. We wanted the system to be modular and scalable. We know that there are 8th edition enhancements that need to happen. There are additional modules that we are going to have to build. So we want to make sure our architecture is built in a way that it will support that. We wanted to try and increase accuracy wherever possible. So whenever users are looking at data, reporting out the data, where are ways that we can get better insights and make sure that the information that's in the system is going to be more accurate. And finally, adaptable and accessible. We are developing a modern application. It's web-based application. So we want to make sure that it's accessible from 508 standards and accessibility concerns for a broad range of users. But it's also adaptable to a lot of different devices and screen sizes. Everything from laptops and desktops all the way down to a phone could interact with this application. And we want to try and think through all those different user contexts and what those users would be doing on those different devices to make sure that the application can adapt and change to those views. Part of the creative brief that we had a group of user personas that we developed. So we went through and we talked to the team and thought about all the different users that interact with the SGS Web application. We thought about what their challenges are and what their contexts are. And what you see on the right-hand side here are some of the metrics that we looked at for all those users that we wanted to try and categorize and really understand. So for each user, we're thinking, is it a technical user that's going to be doing some system administration, or is it more of a non-technical user who might just be gathering information out? How often does that user come into the application? Is it someone who's coming in on a daily basis and needs to use this application to get their jobs done? Or is it someone who's only looking quarterly or annually to try and pull out some data and do some reporting? When we think about SGS Web as the core, we can kind of look at it as users doing one of a couple different functions here. You could have a user that's adding information into SGS Web and accessing it on the other side. You could have a user that's just trying to do research that's coming in. You could have a user that's a combination of any of those things. So we've kind of grouped all of our users and try to categorize them as, okay, is this a user that's inputting, outputting, et cetera, right? And along with that, again, thinking about all those different devices and how they would be accessing the information. Someone who's coming in on a daily basis and adding information on a desktop device is going to want to see a lot more of the application and a lot more information than someone who's using it on a tablet potentially in a courtroom and is just trying to find out what's the sentencing details here? What is the key information from all the inputs that we've had? So again, trying to group these users and think about how the application can support all those users in all their various contexts. A quick hit on what our technology is moving forward. So I mentioned our software architecture that we've spoken with the team. We looked at a high level all the current technology and the more modern web technologies that we want to implement for our new design and interfaces. So you can see those all listed here. Without going into a lot of detail, the high level idea again is we wanted to try and develop an architecture that's scalable and modular and is going to be flexible for future use and future development and future enhancements. So I'm going to hand it over to Rachel, and we can talk through some of the visual elements of the new design.
Thanks, Vince. Thank you. I'm Rachel. I'm the user experience designer. I'm going to go through the visual aspects of the design. So in starting with all the information, all the research that we took away from the first couple phases, we use the software called Azure DevOps to document all the requirements. Our business analyst was spearheaded this, and what you're looking at is a user story. So this is a requirement write-up of all the elements necessary for the specific requirement. So it has a unique identifier, a description, a visual aid, a mock-up if it applies, and then acceptance criteria, which will be really helpful when handing over to developer. They have all the information they need. So this was a really iterative process. There's a lot of back and forth between JMT and SGS and just conversation to get to the approval state, which was critical in being able to move forward. So the mock-ups were support the user stories and also a tool that we got to get to the approval process. We took feedback from the clients, from the business, from the system users, from the technical team and all that, and brainstormed ideas to solve challenges. You're looking at the current system, and I'm going to just click through to show our process of how we got from this point to where we ended up. And again, based on the process of weekly meetings and discussing what's working and what's not working. So the first go, and the contrast is a little difficult to see, but it's a big change. We have this 2/3 layout, or the left side is the personal information of the offender. The right side is the content of the offense or the JP. And then the navigation. So at this point, we kind of just a first stab at it. We worked through the navigation. We added some color coding. We added a step navigation to help the user through the process of building a JP. Another iteration, we lightened it up a bit, still working through that step navigation, trying to figure out the most logical process to accomplish what we're trying to achieve. And finally, we landed here at a pretty clean design that has a lot of information with, hopefully pretty logical as the user walks through the system. So now I'm going to just go through and point out some highlights that we have achieved with the new user experience, going back to our guiding principles and keeping those in mind. The first thing we're going to look at is the navigation. One of the big pain points from the users is that they would get lost or not know how to navigate to a certain area. So we simplified it. You'll see that there are different colors based on which module you're in. It stays active, so the user always knows where they are. We also included a step navigation to help the user through the workflow. So the user knows what to expect, what they need to do in order to get through it, and whether it's adding an offense or resentencing or whatever their goal is. The next big item was making an offender-centric application. You're looking at an offender dashboard. You could consider this a file for the offender, like a one-stop shop. All the information you need to know about the offender is located here. The left side is the personal information. And the right side is all the sentencing information that pertains to this offender. And in the future, the parole information will also be included. The other thing to point out is from this offender dashboard, there's a lot of ways to navigate to take the next step. You can begin the JP, you can add the resentence. So it's all in this one dashboard. We also redesigned the guidelines form. What you're looking at on the left is what is currently, the system currently produces. There's a lot of information that's not needed for a specific instance. So the right side is what we're recommending is a much cleaner, we removed all the information that's not necessary. So the left, I would consider a form, and the right is more of a report of what the sentence is. And you also notice it mimics the website. So the left side is the personal information of the offender, and the right side is the data. We also redesigned the guideline form, the recommendation form in a similar fashion. We highlighted the recommendation. Hopefully this is, a lot, we got a couple on one sheet. So hopefully the user is able to find the information they're looking for and, on the go or on the fly. The site is responsive. We considered how it's going to work for the user, or, sometimes responsive applications are pared down, but we're able to get all the information with the horizontal scrolls for the data grid, the forms stack and realign in order to the user to input what they need. So all aspects were considered, and this is probably on the smaller size, a smaller size phone, and the elements between a phone to the desktop and in between are all considered at different breakpoints and how the application will readjust. Performance and scalability. So what you're looking at here is the process for currently the user has to search for an OTN and then wait for the system to respond, wait for AOPC to respond for an unknown amount of time. So what we're going to recommend is this is the dashboard where the system pulls in the data ahead of time. So we're relying on the system to continually update the database. I don't know if you can see the open circles in the list are all items that are bound over from AOPC. There's no wait time. So hopefully it's a much better process for the user. We're also using an Angular framework, which is newer technology than what's currently used. So hopefully that will be a more maintainable and reusable technology for future use. Data entry was another pain point for some users. There's a lot of redundancy. Where with this offender-centric, the concept is to have the personal information is in one location. So you can update this information in one spot and it is available throughout the site, wherever it pertains to this offender. We also auto-populating the offense gravity score and prior record score. This is an example of the current site where the user inputs the information they need on this somewhat clunky form. What we're moving to is this auto-generated results for the scores that the logic of the system is able to produce based on the business rules that were developed. And then also we are adding an opportunity for data reconciliation so that SGS and AOPC are more consistent sooner at an earlier rate in the process. And then there's accessibility, which is a big concern, which is considered from the beginning to the end of the process. You're looking at an example of a test of the color contrast. So we tested all the colors to make sure they passed and they passed the web content accessibility guidelines. We also reuse the way we present information so it is consistent and the user is able to predict where to find things based on their previous experiences. Whenever we did use color, it's not the only means of communication. There's, an icon or whatever the case is or text. So the user is not reliant on just color if there is a color deficiency. And same with error identification. If there's an error in the input fields, there's not only a red outline around a box. It's also text is accommodating that. So we're not relying on the color. And lastly, the DevExpress is a front end framework that PCS has already purchased, and we're able to use that library and has built-in accessibility. So that's a big bonus to being able to utilize those functions. And so now those are just a highlight of some of the things that we've accomplished in the design, and we're going to move on to looking at what the future state of the application, how we can move forward. The future, the goal is to integrate with the parole board application whenever that's available, integrate with that data so we can pull in that communication between the two, support future guidelines. So as the years go by and amendments are added and future additions are added, the system should be able to support those. And lastly, there's the opportunity to capture offense GIS data. So location of the offense, the location of the offender, all that is an opportunity with this site. In order to get to this point, we have a few recommendations to get to the next step, to get through to development. The first step is to create a critical path for the developers. What needs to happen in order to achieve what part of development needs to happen in what order in order to achieve the goals. We need to break up all the requirements that I kind of showed you, those user stories. How do we break those up so it can be developed in phases? We also need to work with the commission's technical team. There's a lot of logic that goes into automating the prior record score and offense gravity score. So we need to define those rules and figure out, how to build that logic in. And lastly, determine if there's any code that is reusable. Is it from the current site that we can maintain in order to make it more of a phased approach to development? So now I'm going to turn it over to Christy.
Okay. Sorry about that. When we were going through the process with JMT, we really asked them to build the blueprint based on the ideal design and the best solution without necessarily worrying about how we were going to implement it. So now it's kind of time to think about reality and figure out how we're actually going to do this. So if the commission is successful at getting the 8th edition approved to go into effect January 1st, 2024, then we have about a year to get an application built and deployed to users across Pennsylvania. And so that seems like a lot of time, but with a project of this size, it'll just fly by. So what we want to do is kind of narrow our initial focus on what must be done to support the 8th edition guidelines, and then plan for future phases to extend that functionality to other things that we want to do and other things that we need. So for the scope for the first year, we would focus on the core functions and what I consider kind of the foundational building blocks of the application. So we would implement sentencing, resentencing, and risk assessment modules that support the 8th edition guidelines. We would shift the application to be more offender centric because that's kind of what a lot of the design is based on. We would streamline the case creation by automatically importing cases from AOPC, improve the search features, and also implement kind of all the administrative functionality that's just required to run an application like this. And then once we have those core functions implemented, we could start working on the other features, like some of the ones that are listed in the post 1 year section of the slide up there. So whether or not we can do all of these phase 1 stuff in a year kind of depends on the team size, the budget, as well as the approval of the 8th edition guidelines, because we need to have a pretty clear picture of what we're building as far as what are the rules for prior record score and offense gravity score that we need to know what that's going to be and how complex it's going to be to know how long it's going to take us, which you guys are obviously working hard on. So our in-house applications and information technology unit is going to need help with this if we're going to get it done in a year. In our business meeting at 11, I'm going to talk about an RFP that we've drafted to engage a vendor to help us. And then Mark will address budget concerns around the project. So that concludes our presentation. Mark, did you want to add anything or?
No, I first want to thank Vince and Rachel and Christy, of course, for managing this effort. And we'll talk more about this during the next meeting, but more to come. I guess that's about it. Thank you.
All right. Well, thank you very much. Thank you, Vince and Rachel.
Thank you.
With that, we're going to shift to the next part of the policy meeting, so it'll take a minute or two, but we'll move to the consideration of various guidelines.
All right, I think we've made a trading out of the presenters. We're going to continue our policy meeting, turning things over to the executive director to address the different drafts and proposals with the 8th edition of the sentencing guidelines.
Great. Thank you, Judge, and good morning again. We spent yesterday afternoon, 4 hours, I guess, yesterday afternoon, talking about the modifications to the draft of the sentencing guidelines, the 8th edition sentencing guidelines. And we went through that sort of systematically and in quite a bit of detail. But I know there were at least 2 issues that were raised that we wanted to return to this morning. And I do want to make sure we reserve time that we have to talk about resentencing guidelines and recommitment range this morning as well. So we'll carve out about a half hour right now to talk about the sentencing guidelines. The 2 issues that were raised yesterday that I believe we wanted to return to, one was the reasons for sentencing, because we have a list of reasons and there was some discussion about reasons that might be added or removed, keeping in mind that this is not a full and, it's a list that's a starting point for courts to consider. The second thing we wanted to discuss was the assignment for murder 3 and other options for trying to address murder 3 within the matrix or the OGS assignments. So I've asked Ryan to provide us with the materials or the page of the marked up draft that we used yesterday. And I believe it's page 29 of the marked up draft that has the reasons for sentence. And I know at least one of the reasons that was of concern was E1IF, which dealt with victim-induced or facilitated incident. One suggestion was to change that to circumstances that induced or facilitated incident, but there may be other issues. So I just wanted to open that up for any kind of discussions or recommendations related to the text.
If I may, because I was one of the ones that pointed out that I might have an objection to it. I thought about it more, and I have no problem with the change of language. Maybe to me, what I want to convey, and it might be something like the defendant's role or the nature is diminished by actions of other people. Might be another way of putting it. I don't know if people think that works or if it doesn't work, but what I want to convey, and you could just say that it's someone else's action, not necessarily circumstances. I think there's a distinction between that. And maybe I'm looking at it for a distinction without a purpose, but those are my comments. But I certainly agree that we can change that wording. I still have reservations on the value of putting any of them in, but again, I can be convinced that they stay there. I don't have serious objections to that. I mean, total.
Good morning, Mark.
Good morning.
So a couple points I'd like to make. The first one is, obviously, we're having this conversation with an understanding that not only are we talking about the sentencing guidelines, but we're also talking about within the sentencing guidelines, additional, really the way I view it is potential examples of reasons that a judge may use under these circumstances with regard to aggravation or mitigation of the range. Is that correct?
That's correct, as well as departures outside.
And departures outside. And so with all that being said, and an understanding, I mean, from the practitioner side of things, of having gone through this for many, many years, there's arguments that are made on the record at the time of sentencing. There's pre-sentence investigation. Most of the time, if it's a jury trial, the judges have clearly seen the facts of the case and understand it as good as well as anyone else. with all that being said, I have an issue very simply with the fact, and it's actually subsection E, victim induced or facilitated the incident. I just really have a fundamental concern with putting anything in the guidelines that really would put the blame on a victim for a crime that occurs against them. I think that if the victim has played a role in this, then that's something that would come out through the course of the litigation and the adversarial process, and ultimately would be provided to a judge for them to take into consideration at the time of sentencing. So that's my position on that. I feel that it should come out.
Sure. And I guess the question I have is, well, first to frame this, one of the reasons we even talked about including a list was because there are concerns that the reasons given for sentences or reasons for mitigation or aggravation or departure are really limited and really does not provide information to the commission to consider when changing OGS assignments and other things like that. So with that said, and looking for trying to articulate issues that might be in play, Judge McDermott suggested something like defendant role diminished by actions of others. Attorney Marsico mentioned previously circumstances that induced or facilitated incident. Is there any other language that we're removing victim from, but that gets to the issue that there were, other individuals involved? And the thing that comes to mind with me is when we think about simple assault and we think about the three classifications of simple assault, and you have the mutual, fight for the M3, that we have, a recognition there that there's some role, diminished actions by the actor because of some kind of engagement. And we don't want to victim blame, absolutely. But I appreciate the comments that both Attorney Marsico and Judge McDermott made. And I'm wondering if there's some language we could capture that addresses your concern, but also provides something that courts might consider.
Well, I would defer to my colleagues that serve on the bench up here, because they have to deal with these issues every single day from a perspective that's different than mine as an advocate.
Okay.
And so I would be curious to hear what their thoughts were.
All right. Judge.
So my question would be if under B, conduct substantially influenced by another person, whether we leave just that language, because I think that covers it, or even if you wanted to modify it to say by another person's conduct. I didn't know if you add conduct, if that narrows the scope of B, or if that just addresses more of what that the other judges have raised, or the DA has raised, or if we just leave it. But my feeling is that the E, victim induced or facilitated incident, could be covered under the rationale of B and C. And there are going to be certain outlying cases where we're just going to have to articulate facts specific. I'm also concerned with the abusive. But I think instead of making a new E, we either add a little bit to the language of B or we just remove it. That's my opinion.
And just one other point as we're sitting here thinking about this, and I certainly hate to, prolong the conversation, but the reality is, as I'm thinking about prosecuting cases, and I know that, from the lens of a prosecutor, right? So, we prove our case, every element beyond a reasonable doubt. Well, the reality is, in most cases, and I'm thinking of in particular crimes of violence between two people, I can tell you right now that in most cases, defense counsel will argue that a lot of the blame would lie on the other individual involved in that altercation. Okay. And so really the role that's played by the people involved in the altercation, let's say, for example, domestic violence, is something that is litigated thoroughly in front of a jury. And it just seems to me that and again, I'm speaking from an advocate perspective, that we're putting something in here that could potentially really create additional potential litigation that just is unnecessary. And maybe I could be completely off base. Is it necessary to even have that there? And again, I defer to my commission colleagues that are on the bench.
Judge? Your microphone.
Judge McDermott's suggested language was what?
I believe it was defendant role diminished by actions of others.
I like that.
And as compared to or in place of what Judge Bernstein recommended, which was looking at what we have under B, which is conduct
Yeah.
substantially influenced by another person. Is there a substantial distinction between the two that we want to get at, or does B provide enough coverage, or modified B provide enough coverage? I take that we're taking out E. We're taking it out. The question is, do we replace it with something, or do we just rely on B? And again, this is just for purposes of approving for public hearings, where I'm sure we'll hear more about it. But I think this is a helpful discussion, but this is not the final adoption. This is to put something out for further comments.
Would it, Judge McDermott, if we use B and added another person's conduct as opposed to just another person, does that encompass?
I certainly think it's interesting. When I look at B, my head traditionally goes to where I would phrase it in cases where there are co-defendants. And a lot of times I have a younger co-defendant and the conduct has been influenced by the co-defendant. That's where my head went for that, where I just was trying to make a distinction, and I think we can clean it up however people want to clean it up, or I would be satisfied that I'm trying to backtrack. What I'm saying is, I guess you looked at that differently. And you see this as encompassing anyone's behavior. So maybe just a word in there by any other person. I don't know. I mean, I can live with it, and I think it is for public comment, but that's why I wanted a distinction. But again, it was in the mind of the beholder. I went automatically to the co-defendant, not to people outside of the incident, because that's the one that I use all the time when I have someone in those situations.
So
But
changing B to conduct substantially influenced by any other person, a slight distinction or slight modification, but it might.
Yeah, and I'm not sure that makes a difference.
Okay.
But I'm not committed to the language. I'm committed to the idea.
How
That's
about
all.
at least for now?
Yeah.
I'm going to propose that we just remove E and move forward. That's okay.
Fine.
And see what we get through public comments.
Work.
Great. Thank you. Okay. So the next issue is, if that wasn't good enough, we'll move to murder 3 discussion. So we had a long discussion yesterday about the difficulty in coming up with an assignment for murder 3. So I'm going to ask Brian to put up the matrix and just the top part of the matrix, and just sort of recall sort of where we left this and what's on the table, and at least some of the discussion we have to see if we can reach consensus. So right now, under the proposal, well, our starting point is presently under the guidelines, murder 3 has a really wide range. It's an OGS 14. The range is a minimum of 72 months up to the statutory limit, so 240 months. When we look at the data for 0 prior record score, no enhancements for murder 3, what we found was that about 25% of the cases had a minimum sentence of the statutory limit, 240. And that was the mode. That was the most common value. And then next highest in values were 120 months and 180 months. So we have, fairly high sentences being imposed under the current guidelines with that really broad range. One of the issues that is, we think underreported and underused is the deadly weapon enhancement. At least it's used inconsistently with murder 3. And the deadly weapon enhancement would increase, or does increase, the sentence recommendation for deadly weapon possessed from 72 months up to if I can find up to up to 84 months, I believe, 81 months. And then for deadly weapon used, up to 90 months. So for deadly weapon used, murder 3, the range is 90 months to statutory limit, 240 months. So under the proposed guidelines, we were trying to look at what the median sentence was, which was 144 months. And we were taking into account that we are required by statute to have an enhancement when the victim is less than 13 years of age. And so what the commission decided to do, or what was in the proposal, was that there would be an OGS assignment of 28, which would be 114 to 138 months for murder 3, and an OGS assignment of 29, one step up, of 138 to 162 when the victim was less than 13. So that's at least what we have in the draft proposal. The highest we can go for murder 3, at least in this matrix, is to 30, which is, I can't even read it from here, but I think it goes up to 186. So, and that's far below what the typical sentence is right now, or what the modal sentence is right now. One of the recommendations yesterday was to create an additional sentencing level that was exclusively for murder 3. And there's a couple of justifications for this. Number one, we have a level H, which is reserved for murder 1 and murder 2, that deals with the Miller cases and with standard murder 1 and murder 2. So we have that reserved for murder 1 and murder 2. F is used for effectively felonies with a statutory classification of greater than 20 years. And so in that category, aside from murder 3, we have inchoate murder, serious bodily injury, we have rape, child less than 13 years of age. We have a number of other felonies with statutory max of greater than 20 years. And so it makes a lot of sense to retain F and use it for many of those assignments. So the suggestion was, how about if we insert a level G? It would be almost an overlap level, but it would be exclusively for murder 3. And at least initially, for the purpose of these guidelines, we would retain something similar to the current sentencing guidelines, where we would create a base and allow the statutory limit for any of the cells, any of the recommendations we make, but build into it a recommendation or a requirement that courts provide specific reasons. Because one of the problems we found is we just don't have, murder 3 is all over the map, and we don't have really good information on what's happening and how we could better distinguish the OGS assignments. So the recommendation would be that we add a level G between F and H, that perhaps we have 2 categories in it. Think of G1 and G2, where one of them is something similar to our current assignment, either 72 to the statutory limit or maybe 90 to the statutory limit, because that's what the deadly weapon used enhancement is, and which generally applies. And then for victim less than 13 years of age, have some step up, maybe to 114 or something like that as the base, and move ahead. One example, and Ryan, I think, because I can't see that, so one option is to consider some existing OGS assignments as sort of an example. So for instance, if you said G1 was a base of 90 months, that for murder 3, 90 months the statutory limit for a 0 prior record score, we could then look at other sections of the existing matrix. If you look at 27, you'll see 90 to 114. And we could, in effect, use the base of that 90 months to statutory limit for murder 3. And then we could, for prior record score, move across that column. So murder 3 for a prior record score of 1 would be 114 to the statutory limit. 2 prior record score, 1, whatever that number is, 138. I have like an eye exam today. It's to the statutory limit and so forth. And then if you say, okay, well, that's what we'll do for that G1 category, murder 3, maybe the victim less than 13 is one step up. And so we use the 114 to statutory limit as the next category and so forth. So that would be one way to structure and sort of isolate murder 3. We would not be relying on F for murder 3. We'd be creating its own category. And we could include a requirement for better reporting or better information about murder 3 to help the commission in the future in terms of coming up with this. And what it does is it's consistent with what we've done with the rest of the guidelines, where we really try to use as a starting point the sentences imposed by courts to like anchor our recommendation. And when our median is 144 and our mode is 240, we don't reach that, and certainly not for victim less than 13 with the existing categories in the F. Judge?
Mark, I think, we did talk about it a lot yesterday and at least at our table a lot last night. I think that makes sense. A murder 3 is an anomaly. And I know staff has tried to tighten up the ranges here dramatically and done a good job. And I know this sort of throws that out of whack, but I just think with the way our murder 3 is, with all that it encompasses, both from a substantive law standpoint as well as from a sentencing standpoint, you have that jump from life for first and second down to the max of 40 for third, which really is a minimum of 20,
Right.
As we all know. So it just, I think it really needs to encompass that. And I think if you do anything other than that, you're going to force a lot more trials because you're going to take away, not that because it's a plea agreement, judges wouldn't accept it and do it, but I think you have to include that statutory limit in there when, as we've, and I can't believe I'm using this word, seen the mode, actually is whatever. I think I know what it means now.
Yeah.
But the statutory limits so much. I think that makes sense to carve out that G1. We didn't talk last night, but we obviously came up with how to hit the different prior record scores. I think that makes sense too. And as I said before, again, outside of judges putting some reasons on, I really do think we should look to one of our research partners to dive into what is the universe of third degree murders, like as you referenced for the interbranch commission study did with first degree murders and capital decision making, that we could figure out a little bit more. But I do just think it encompasses so much behavior that you need to account for. Yeah, maybe it should be a 8-year sentence, maybe it should be a 20-year sentence.
Okay.
And as Judge McDermott said yesterday, and she was a trial attorney at the time. I was a prosecutor at the time doing homicides. When we moved to that 20 to 40, that actually gave us a lot more room to negotiate and cut down a lot of murder trials.
Thanks. I should clarify one thing in terms of the deadly weapon enhancement. Just because of how we have changed the approach by doing the increase in the steps, that really wouldn't apply if we create this new category for murder 3. And so that's why the assumption might be to use 90 months as the base of it, exclude consideration of deadly weapon enhancement, and rely on the court providing reasons for the sentence. And then it keeps it simple. The other thing that it does, just sort of categorical, is you have then 2 categories that are reserved for murder, and they're treated differently. We could relabel the murder 1 ones as H1 through 6, and then the murder 3 1 as G1 and 2, or something like that, just to keep it simpler and less crowded, but also to sort of distinguish that these are different than the rest of the felonies and misdemeanors we're dealing with through the guideline. Judge?
I was at a different table.
Yes.
However, I applaud your efforts, because I think what's a fundamental difference between the charge of third degree and almost any other charge is the behavior for burglary is simple. You enter with the intent to commit a crime. It's a different degree, whether it's a commercial establishment or a house. The 3 degrees of robbery are very simple. The third degree murder charge encompasses, I think Judge Marsico was touching upon this, a completely broad range of behavior, where it could be like a single instantaneous incident like a lot of those ones that you displayed yesterday, like a parent killing a child versus, someone out on the street corner splaying the street corner. So I like it. I mean, I think it recognizes that the behaviors can be so different within that specific charge that the guidelines have to recognize and give us judges the ability to sentence appropriately. That's it. I was just trying to focus a little bit on the definition is so broad. And like we discussed that there's a distinction between someone who is pleading to third when it's to get a reasonable resolution of a case when it's first versus someone with, let's say, an offense gravity score of 0 that just makes a split-second bad decision.
Mhm. Yeah.
So thank you for those that came
thank-
up with the idea.
Judge Bernstein. Any other? If there's no other comments, we'll just redraft that for,
The only question I have is when I think the idea of the 27. So I guess the way I was just thinking of it is the ceiling remains. It's just the floor that we keep bumping
that's correct.
with the prior record. And I think 27 makes sense. I like the idea of starting at 90 at the floor. The question is then when it becomes a child under the age of 13, do we want to do a 1 step up OGS or 2? So if we do a 1 step up with a prior record score of 0, we're looking at a 2 to 4 year greater floor. If we go up above that, it's a 4 year to, I didn't do the math, floor. So I just think maybe if you wanted any input from anybody about which of those two they think is appropriate,
Sure.
or if they have
Hoping-
any other thoughts about where we start and where we step up.
Right.
Does everybody think that 27 is a good cell or a good OGS to follow in the as the floor for the murder 3, the general murder 3?
I could say under the old, one of the examples you gave under the old guidelines, it was 72.
72 without a deadly weapon enhancement. So this would in effect build in the deadly weapon enhancement, which we, at least based on the research we did for HR 111, the vast majority of murder 3s would have a deadly weapon enhancement or should have it applied. But it wasn't. So this would at least provide consistency in the application. And the thing is, if court felt that, that it wouldn't have applied, that's one of the reasons the court can give in terms of the reason for preventive.
And if I may, real quick, Mark, I agree with what everyone said. I agree with Judge Bernstein. And I think that for what it's worth, as I'm sitting here thinking about 3rd degree murder cases that I have seen, I mean, the fact patterns and the levels of the types of culpability are so vastly different that the last thing we want to do is pigeonhole a judge into a place where they don't have the flexibility to render a sentence that reflects that. I mean, and I think that I don't know if compromise is the right word, the dinner compromise is I think that it achieves the goal that we're trying to find here, which is just outcomes, holding people accountable, protecting victims. And so I feel comfortable with it.
So maybe I can ask, is there anybody who opposes or wants more discussion that murder 3, where the victim is 13 or above, will be statutory max at the ceiling and 90 for a 0 prior record score is the base for the floor? Is that right?
Well, 90
Judge-
for murder 3. For
But-
less than 13, it would be
No,
at least one
I would
step.
say when the victim is over
Over 13. I'm
13
sorry.
as the
I
base.
misunderstood.
And then, so the
Yep.
second, is there anybody who has any more discussion on that? And then the second question is, if the child is under 13,
I think Judge McDermott had.
I'm sorry.
I'd like to leave it at 72. I think it's comparable and I think it covers those incidents where there is no deadly weapon enhancement. But I can live, I'm just going to say, if we're trying to keep it consistent with the guidelines, and then that recognizes that percentage that you put up yesterday, which was significantly lower. But as usual, I don't think we have to have consensus. I think majority rules.
Sure. So if we were to use 72 as the base, that would be effectively OGS 24 as the base that we would use and statutory limit as the top. And then that would give us more real estate to have a higher OGS distinction for victim less than 13.
Okay, so we have two possibilities on the table. We take it and keep it at 72. It doesn't coincide with a particular OGS that currently exists, but isn't a requirement. And then in terms of the step up for the prior record score, would you follow the matrix of OGS 24?
Yeah.
Okay.
Yeah. So the statutory limit would be the top of the range, but the 72, 84, 96, 108, 120.
And then will a deadly weapon enhancement?
It would
be-
not apply. No deadly weapon enhancement applied, but
Right.
the court could, because you have from 72
Sure.
up to the statutory max, the court could articulate that as a reason, because it wouldn't be practical in terms of how do you add the deadly weapon, because we're creating two new categories, right? So you couldn't step up, especially from victim less than 13. So if you went with 24, the question, or maybe one option would be that for the victim less than 13, you use the 90 as the base for that. So it would be effectively 24 and 27 as the OGS assignments for G1 and G2, with the exception that the statutory limit is the top of all of this range.
I'm not sure if this answers the chair's question, but as we're walking through this, I just want to make sure that I understand. So the proposal is that if it's murder 3 and child victim less than 13,
Mhm.
younger than 13, then what would the starting range be for that?
That's what I was saying. The one option is to use the 27, the OGS 27 as the base of that. So if the victim is less than 13, the 0 prior record score, the range would be 90 to statutory limit, prior record score 114 to statutory limit, and so forth. So you're using the base of OGS 27 for the for G2.
Right.
And you'd be using the base of OGS 24 for G1 for a victim older than 13.
Right. And that's versus if the victim is older than 13, 72 months.
72, right? That
Okay.
would be the OGS 2024 base.
Thank
Oh.
you.
Okay, so I'm going to ask, we have two proposals on the base of a murder where the victim is 13 or greater. So the first was a discussion about using OGS 27. Judge McDermott raised that she likes, and then based on the studies that were done, that we maintain the 72 as the floor. Is there any further discussion on the preference of 72 or 90? Is there any, go ahead.
Do I understand the reasoning that part of the argument for raising it to 90 is because there's often a deadly weapon enhancement that isn't used that would be baked into raising it to 90? Is that
No, it has more to do that we have a statutory mandate to have an enhancement in place when the victim is under 13 years of age.
Right.
So we have to make a distinction between murder 3 generally and murder 3 when the victim's under 13. And because the discussion we had as a starting point was using 90 as the base, I was just using the 90 as that base for under 13, with the understanding, as Judge McDermott said, that we use the current OGS assignment or base of 72 for victim older than 13.
okay?
But I think when we first started this discussion, you had started at 90 as a starting point.
I
And you had
had.
indicated that one of the rationales for that was because almost always a deadly weapon is used. I
Right.
think that's what you were
Yeah.
referencing. That's why we hit that
Oh,
number.
That's correct. And,
Yeah.
and I was just, yeah,
So
absolutely.
is there anybody who is opposed to keeping the OGS at 24 so that for a murder of a victim 13 or older is a floor of 72 with a statutory max or statutory limit as the ceiling? Everybody's okay with that. So then the next question becomes for a child. If we go up to a 27, that is at the base, a 1.5 year step up. So basically, if you are at the bottom of the standard range for somebody 13 or older, is everybody okay with 18 months as a sufficient increase for a child victim? Or do they feel that we should go up any steps beyond that? Question?
What does that look like in the current guideline?
The current, well, it doesn't really, because the current guidelines, the highest level is 72 to the statutory limit.
Okay.
So we
there's
don't have
no
we don't have
enhancement.
means of going higher.
And just so I understand, so the reality is with the proposal of starting at 90 months, that actually is higher than what the current guideline calls for.
It is, and I'm trying to think if we have language in the current enhancement that provides X number of months, like 12 months or 24 months, and I'd have to look at the current, but Ryan might be able to look at the current enhancement for murder 3. I know we try to use the step up, but it's not available if you're starting at 14 right now. So,
And I think it's also clear for people, you know, as well as we think through this also, the reality is the starting point, it's a range. It goes from, it could be 90 months through
the statutory limit.
statutory limit.
That's all I'm saying. Is
So it's
everybody,
always,
is everybody
we're always
okay?
talking about the base of the range.
So is
Before we
everybody
get to this.
okay for a victim under the age of 13 with a floor of 90 months, which is OGS of 27? Is there anybody opposed to that? Right. So, and I
Yeah.
think it would ID just like the murder does, where you put the age underneath. So I think if I understand it correctly, the commission is in consensus that a murder where the victim is 13 or older is an OGS of 24 to statutory limit, regardless of the prior record score, and we'll follow those step ups. And for a victim under the age of 13, we're looking at an OGS of 27, so a floor of 90, stepping up as it does in those cells, but always with a statutory limit as the ceiling.
And I
Right.
apologize to Judge Dowley's point. Under our current enhancement, because we cannot step up an OGS, the enhancement adds 24 months to the lower limit of the standard range. And I believe it's 24 months to the top of the standard range. So it's 2 years rather than 18 months.
So that falls within 27.
It does.
Based upon that information, is everybody still okay with that, or have to create a different?
Yeah, I
Right.
think 90 captures it. It's just, it provides, it's a little bit lower, but captures. So we will rewrite this with G1 being a base of 20, based on OGS 24, and G2 for under 13, a base of OGS 27, statutory limit. Thank you all very much.
One other question.
Sure.
So, but the current guidelines have it up to the statutory max,
Up
right?
to the statutory max, absolutely.
And we're reducing it.
No. In all of these cases, we're going to have statutory max for murder 3. It's just what the base of the range will be. Okay, great. Thank you all for that. So to try to bring a close to the draft sentencing guidelines, we covered a lot of other things yesterday. Again, this is for approval to have public hearings, so it's not final, but we are getting very close. So are there any other issues that need to be considered before we take this to our next meeting for approval and scheduling a public hearing? Well, you have between now and then to figure that out. But if not, let me move on then so that we can deal with the other two sets of guidelines that are before you. So again, this is in the meeting materials in the commission supplemental materials, starting at page 264 is the amended text of the resentencing guidelines. And as you may recall, we've had resentencing guidelines for a number of years, required by statute to have the resentencing guidelines. They focus on violations of probation. So if at sentencing, someone is placed on probation and subsequently violates conditions and is revoked on probation, the matter goes back before the court for resentencing. And prior to the mandate to the commission for resentencing guidelines, the court could impose any sentence the court wanted to up to the statutory limit. It was like starting all over, like de novo. And so the mandate to the commission was to create sentencing guidelines for consideration by the court when resentencing on those probation violations. And so we enacted the initial resentencing guidelines a couple of years ago, and then we did one amendment, and the amendment was took into account the repeal of county IP and state IP, because at the time our mandate was to anytime when the court was resentencing, so it was probation, county IP, and state IP, we had to have guidelines. when county IP and state IP were repealed, we had to amend the resentencing guidelines to just focus on probation. So we did that. And the bottom line is, for a technical violation of probation, the recommendation is go back to the original guidelines. And one of the considerations, one of the amendments that we put in was that the court should take into account the sentence originally served. And the key to that was that we had heard from courts where there was a heavy use of split sentencing. But think about a case where a person is sentenced under the guidelines to a standard range sentence, but it's a confinement sentence. Maybe it's even a state prison sentence, and someone gets a 5 to 10 and a consecutive 5-year probation. And they successfully complete the 5 to 10, and while on the probation, there's a violation and they're revoked. Well, under our initial guidelines, it would come back to the court, and the court on the probation violation was considering the original guidelines without any notation or any comment about taking into account the person served a 5 to 10 already on this sentence. So we amended those guidelines to just say, take into account the original sentence that was served when you're resentencing. So that's what's in place right now for technical violations, for convicted violators, for someone who is convicted of a new offense while on probation and the probation is revoked. What the commission has built into the guidelines is a slight increase in the original recommendation by effectively shifting the prior record score by one category. So if someone had a 0 prior record score when they received probation and they come back on a probation revocation because of a new conviction offense, the prior record score effectively is a prior record score 1 for purposes of a sentence recommendation. Because of the restructuring of the sentencing guidelines, what staff is recommending is, instead of changing the OGS or adding one to the OGS, just adjust the offense gravity score by 1. The whole system we're putting in place with the new guidelines is based on, for enhancements and everything else, just increasing the OGS sort of consistently. And so that same principle could apply to this, where we say if there's a revocation of probation and it's because of a new conviction offense, you come back, you look at the original sentence recommendation, you increase the OGS by 1 and use that as the range. So that's the one key distinction in these resentencing guidelines as compared to previous. The other thing is that we wanted to put in place a system where the resentencing guidelines effectively are paired with the sentencing guidelines. So when we have resentencing guidelines in place that are used for the 8th edition sentencing guidelines, they're sort of a couplet, right? So because you're going back to the guidelines that were used when the person was sentenced. So if you were sentenced under the 8th edition guidelines, you're placed on probation, and now you're having a revocation, you go back to the 8th edition guidelines. So it's just making clear in the resentencing guidelines that they connect directly to a specific set of sentencing guidelines. They're like an addendum almost to the sentencing guidelines. So that is, I think, was understood in the past, but we made it explicit in these. So those were the only two changes that we were recommending under the amended text to the resentencing guideline. So if there are no questions or concerns, yes, Judge.
I'm sorry, I do have a question. I just
Sure.
want clarification.
Yep.
So what we're basically saying is, if the criminal act occurred under the previous guidelines, and I think that just has to be crystal clear for us judges, you're not applying the guidelines in existence at the time of the crime, but you're now applying the guidelines that are in existence at the time of revocation.
No, absolutely.
No, that's what I was going to say. 'Cause I thought it
opposite.
was the opposite.
Right.
And then when I was hearing it, I was like, whoa.
No,
okay.
we are
Sorry.
pairing the two together. So if you are sentenced under the 8th edition guidelines and you're placed on probation, a revocation of that probation is under the 8th edition guidelines,
That's fine.
which sort of makes sense because you're going back to the guidelines that were in place at the time of sentencing. but it wasn't explicit in how we had it written before. So we're trying to make it explicit
Okay,
now.
that's good, because when
Yeah.
you were explaining, I was like, wait a minute, did something
Yeah.
change? Okay, thank you.
Yeah. Sorry.
that's
That's me. That's me. Yes, Representative?
Quick question. Could you explain the rationale on the OGS increase for when it's a conviction violation?
Sure. The commission in drafting the original resentencing guidelines, and this is consistent with recommitment ranges on parole that we'll be talking about in a minute. But they thought there was a distinction between a person on probation being revoked because of technical failure to abide by the rules versus someone who commits a new offense and is convicted of a new offense while on probation. And so the commission always thought there should be some type of enhancement to the recommendation because of a new conviction offense. Under our old system, or the current system, we use the prior record score to achieve that. So we said, if you come in and it's a new conviction offense, instead of, prior record score 0, we're going to bump it up to a prior record score of 1. Well, now we've just sort of flipped the axis, and we said under the whole new 8th edition guidelines, everything is an adjustment to the OGS. It's just one step or multiple steps up. And so let's just use that, because we've now structured the OGS that's more regular and consistent. So it's more proportional to just use an OGS increase. So it'll be a 1-point increase. The other thing that was awkward under the current resentencing guidelines is at some point you would cap out. There were only 8 prior record score categories, and we excluded 2 of the categories that were special, like RFL and REVOC. So there wasn't a lot of real estate in terms of continuing to build up if someone's a repeat violator. Whereas with the OGS, we have 30 ranges now. So and probation is the most common and lower one. So it gives you a little bit more of a sort of systemic approach that you can take.
So just a clarifying question on that. Would there be a scenario based on someone's prior record score where in calculating the new conviction, the prior record score just based off of past convictions could also bump up and they would also get a point increase in the OGS from the conviction violation?
No, because the formula we have is that you go back to the original guidelines that were in place at the time of the original sentence, and then you supplement it by 1 OGS because of this new offense. The way that our prior record score works is that you take into account any convictions prior to the commission of the new offense. Okay. So there are 2 different issues, but it is a good issue to consider separately, just thinking about like how prior record score works, because when someone is convicted of a new offense, they're going to be sentenced under guidelines for that new offense while they're also going to be revoked on the probation, right? And so this is a focus on the probation. But remember, generally speaking, and not always, but generally speaking, the same court will be thinking about both the new sentence on the conviction and the resentence on the probation violation. So we'd hope there'd be coordination there or consideration of both. So that is it's a separate issue. I think it's an important issue we've talked about before in terms of encouraging judges to think holistically about what kind of sanctions being imposed for this violation, because there will both be a new sentence and a resentence on the probation violation.
Okay. Yeah, that makes, I think my concern was just, would there be a way where, given this change, like could something end
it
up
won't
double
impact the prior record score, but coordination is really important, and we'll talk about that with the recommitment ranges.
Understood. Thank you.
Great, thank you. If there aren't any other questions, we'll take that to our next meeting. And now we turn to the final issue, and this is the recommitment ranges, proposed state parole recommitment ranges. This starts at page 268. I want to recognize the chairman and the board secretary who are with us today, and also just publicly thank the board for all of their help over many years. I mean, we've been working with the board, well, for a long time, but particularly in recent years, you might recall that the commission adopted, submitted to the General Assembly parole guidelines, initial parole guidelines, and those will take effect January 1st of this year. And we've been working with the board, and they've been extremely helpful in just implementing and providing education, and then also developing a mechanism for the reporting of information. So it's been an incredibly positive and good experience. And that has extended to our work on recommitment ranges. So you may recall that the commission, at the time we were working on parole guidelines, we were also working on this recommitment range. And recommitment ranges, similar to our resentencing recommendations, deal with someone who has been placed on state parole, so released by the board to community supervision, state parole supervision, and while on state parole, is revoked. It violates either conditions of parole, so technical violation, or is convicted of a new offense, convicted violator. And so we were required under statute to create ranges, recommitment ranges for both of those circumstances. And just to be clear in terms of terminology, if let's just use an example that someone receives a 5 to 10 year sentence and is committed to the Department of Corrections and serves 5 years, and the board reviews the case and decides to parole the person at 5 years. Because remember, there's no right to parole. It's discretionary parole. It's the discretion of the board, and the board makes a decision in this case to release someone at 5 years to the community. And then that person will be under community supervision, parole supervision, for the unserved balance. So the 5 years remaining on the maximum. Because of recent changes in statute, the Department of Corrections now provides that supervision of the cases, but the board is the decision maker in terms of paroling and recommitment. So if someone is out on parole and is alleged to have violated conditions of parole, there's a whole process in terms of determining if there's a violation of parole, and that comes before the board, and the board can make a decision. If they determine that there is a violation, then the board can recommit the person to the Department of Corrections to serve all or part of that unserved balance. So when we talk about recommitment ranges, it's a recommendation to the board for the amount of time that the person would be sent back to the Department of Corrections or to one of the community facilities to serve additional time in that original sentence before being eligible for consideration for reparole. That's effectively recommitment. They're the ranges, the recommendations we're coming up with. And we are required by statute and certainly by board practices to have separate recommitment range recommendations for technical violations versus those where you have a convicted violator. And in statute, there are explicit provisions especially regarding technical violators that especially came out of Act 122 of several years ago that put limits on how much recommitment time there can be for technical violations. So we are, the commission in drafting the initial recommitment ranges that we had for public hearings really tried to adhere to what the statute provided. We did get some feedback during public hearings that we could have been maybe more generous because we were creating some ranges that seemed to maybe increase beyond what statute required in terms of the recommendation. So we took that seriously. We also looked back at the enabling legislation, the requirements we had about all of the factors we're supposed to consider. And we found, as we heard in public hearings, that some of the factors were not being considered fully. And so we had the opportunity during the last year to work with the board, participated in their retreat, had a lot of meetings with board members and staff, with their chief counsel and with the board secretary. And I think we've come up with what I think is a really helpful set of ranges. And I think it's an improvement over what we had. So I'm going to sort of cut to the chase. In the document that we provided, which is a rewrite of earlier published proposals for recommitment ranges, we've come up with two tables that I think summarize our recommendations. And Ryan, if you could move to the last page. Thank you. So again, recalling that there's two types of violations or recommitments, technical and convicted parole violators. The top one, table 1, is the technical parole violator recommitment ranges. So in statute, as I said, as a result of Act 122, there was a real concern about individuals for revocation for technical violations being recommitted to the Department of Corrections. And there was an emphasis on the use of community correction centers, community corrections facilities, those types of facilities for those individuals, including what are called parole violator centers, right? So the idea was to really favor the use of those facilities for recommitments rather than a correctional facility like a state correctional institute. But there were exceptions. And one of the sort of exceptions was 5 or 6 different like violence indicators, violence acts, where the board was given the discretion to recommit the person to a state correctional facility, an SCI or a contracted county jail. But the legislation then set forth different conditions. And when the legislation first took effect, they said everyone starts at 0. And if this is a first violation that sort of fits that list, the recommitment to a correctional facility should be limited to 6 months. I think 6 months, if I can read this. And then, you know, the second violation limited 9 months, and the third violation, way better. And the third violation, 12 months. So when the commission developed its first set of recommendations for recommitment, we took those upper limits, which are maxes based on statute, and we created a range. And if you look under the column that says violent, you'll see pretty much what our original recommendations were, like a range of 6 to 9 months, a range of 6 to 9, 3 to 6, 6 to 9, and 9 to 12. During public hearings, there were some comments like, why do you set that range? Because effectively you're recommending a longer recommitment time than required by statute, because the statute only had a max on it, not like a minimum term of recommitment. The other thing that was required for us to consider under the enabling legislation, but that we didn't consider, was we're supposed to look at the reason or the seriousness of the original commitment offense. So, you know, John Doe is committed to the DOC for some offense for which he is paroled. And now while under parole, he is revoked and he's being recommitted. So we focused on, okay, he's being recommitted. Is this a first time or second time or third time if it's one of these special things? But we didn't say, oh, what was the original commitment offense? Because we were supposed to look at that too. So I'm going to try to connect the dots here. If you think about when we adopted parole guidelines, we came up with 2 categories of offenders under the parole guidelines: violent offenders and non-violent offenders. And it's based on not only the committing offense, but the person's priors. And so we have separate parole guidelines for violent versus non-violent offenders. So what we're suggesting here is that we use those same categories that a person was paroled under, whether they were in a violent category or non-violent category. And if they're in the violent category, we go with the recommendations we had that are sort of a minimum period or a maximum period of recommitment. And that's the 3 to 6, 6 to 9, 9 to 12. But if the person is a non-violent offender, then we basically just provide the caps that are available in statute. So the board has discretion to give less than that. And in fact, our recommendations to the board only apply when they decide to recommit someone. If they're not going to recommit someone, these don't apply. So it's only when they apply that we're providing a recommendation of what the duration of that should be. So that's why for the nonviolence, we're just going to use the cap that was provided in statute and allow the board to exercise its discretion, which is what was recommended during public hearings for some of these cases. So I think we're both addressing what was in the statute, addressing what we heard in public hearings, and and deferring to the board with the exercise their discretion in these nonviolent cases. So that's one of the changes. The second change is we did not build in for technical violators those cases that weren't violent, those cases that were being recommitted to a community correction center. And so that's what the gray shaded area at the bottom is. Those are just like the typical cases where the board decides to recommit someone to a community facility, a community correction center. And all this does is just put some recommendations about sort of a cap. But again, these are just advisory guidelines, but it's us doing what we're required to do in statute, but deferring to the board on their exercise discretion. So the third area, and this is on the right-hand side, that shaded area where it says disciplinary infractions. Even though there's all these rules in the statute about what the recommitment time to a correctional facility is for first, second, third, or subsequent violation, there's an exception in the statute that says if a person was committed to some kind of facility and there's a whole list of disciplinary infractions, then both the automatic reparole and the time frame that the statute provides do not apply. So the board has discretion in those cases to determine the back time or the recommitment time, and that there is not automatic reparole, which applies in some of these other cases. So we carved that out to say in these cases, we're just going to have a higher cap that would otherwise be present. And it'll be, again, up to the board to exercise its discretion. But we're recognizing that these are different cases. And these will not be automatic reparoles. These will be cases where the board exercises discretion. And the thing about this area is disciplinary infractions could happen, at different points in the system. So for instance, if someone is in the community on parole and there's a revocation of parole, there's a technical violation, a detainer could be filed and the person could be committed to a facility. And while there, they could engage in some of these disciplinary infractions. Or if someone was recommitted to a facility and while serving a recommitment, they did some of these things, that could happen then. So there's a lot of different points in the system where these disciplinary infractions could occur. We just want to make sure the board has discretion to recognize those, to not have automatic parole, and to have sort of an upper boundary that recognizes the more seriousness of the nature. So those are the differences to the parole violator recommitment ranges than what we published previously. Judge?
Mark, on a new conviction,
Yeah.
Does the parole board have the discretion as far as concurrent or consecutive?
They do not, and we're going to get to that next.
Okay.
So these were all about, this first table is about technical violations, but now we're going to move to the next, which is table 2, which is convicted parole violator ranges. Judge?
And I don't know if this has anything to do with the commission. When you said when they look for violent offenses, they look at the underlying offense for which they're being violated. And then they also look at their history.
Mhm.
When we just talked about all of our lapsing, et cetera, is that just separate and apart from this, or does that come into play with when they're looking back?
Yeah, it's separate and apart. I think the benefits of the violent, nonviolent indicator is that we have built that into the parole guidelines. So in the parole guidelines, there is a whole system in place that the board has had for a while, since I think Goldcamp, to try to identify violent offenses and whether they're current or present, and then say these require a little extra consideration. So we're using that instead of probate sentencing guidelines.
Thank you.
So moving to the convicted parole violator recommitment ranges. This gets to the instance where someone has been released on parole and not only commits a new offense while on parole, but is convicted of that new offense. And that's a key consideration. These are not allegations. These aren't anything other than a conviction. If a person has not been convicted of that offense, they are not a convicted parole violator. So these offenses, these guidelines, again, they relate to when a person is being recommitted by the board. If the board decides not to recommit, these don't apply. So these apply when the board decides to recommit someone, and then we try to look at the details of that individual. So we once again are using the two categories from the parole guidelines, whether the person's nonviolent or violent. And then we're taking into account the seriousness of the new conviction offense. And someone could be arrested and convicted of a whole bunch of offenses. We know that. And so this is based on the most serious conviction offense, right? So we're just looking at that most serious conviction offense. We were trying to find a systematic way to link this new sentence that's going to be imposed by the court with the recommitment ranges being considered by the board. And again, it's sort of like when we talked about probation resentencing for probation violations. There's going to be a new conviction sentence, and there's going to be a resentence for the probation violation. Well, the same occurs when someone's on parole and there's a new conviction offense. The judge is going to sentence on the new conviction offense. The board's going to act on a recommitment for the existing parole time that was not served, right? So we tried to look at how we could coordinate the two of these. And one of there's a lot of problems here, but it does get to the issue that there's not always great communication between the court and the board in terms of how this is functioning, how this is working. Sometimes it's because it can be inconsistent in terms of who goes first, right? You might have a conviction offense, but not a sentence yet, and the board's trying to act on the recommitment. Or you might have a sentence, and then the board is knowledgeable about that, but the court might not know what the board's going to do or what they might do or whatever else. So the idea of trying to come up with a scheme that puts both of them sort of on the same table is helpful, at least for helping to start that communication so that you sort of have some indication of what the other party's doing. So for instance, if you look at this scale, what we've done is we've taken the new matrix, the 30-point matrix, and we've 36-point. We've taken the new OGS listing and we've looked at those levels of sentencing, which get to the seriousness of the offender. And we're going to use that as a mechanism for deciding how serious the new conviction offense is for purposes of a recommitment range. So as an example, let's say someone's on parole, they're a nonviolent offender when they were paroled, and they are convicted of a misdemeanor offense that has an OGS 5. So the board will know the conviction offense because we have it in our system that it's an OGS 5 conviction offense. And so they'll be able to look at this matrix and say, OGS 5, that would be under level B of the guideline. And this is a nonviolent offender, so the recommitment time that we're recommending them is between 6 and 12 months. And these numbers are based sort of roughly on existing regulations the board uses for recommitment. So we worked with them. It's not as standardized, so this would standardize it. And we would have an assignment for every conviction offense because, we have the guidelines in the matrix. So this would consistently apply these guidelines across all new conviction offenses that the board would encounter, which isn't in place right now. So the board would know right away, based on the OGS and the corresponding sentencing level, what the recommitment range recommendation is. But the thing is, the court would know what the board's going to consider too, because when the judge is sentencing on that offense that's an OGS 5, the judge now knows that the board is going to be considering a 6 to 12 month recommitment range. Now, they might not do that, and you might not sentence within the guidelines, but I think for the first time, both sides will sort of know what the starting point is for the other side. And I think that's helpful in promoting coordination. And then, Judge, to your point, if it's a convicted violator, I think by operation of statute, it's automatically a consecutive sentence. And that the service of sentence depends on, what facility, and are you released from that facility and going, it's not easy, but there's rules that apply in terms of the service of sentence. But I think at least in case law, the bottom line is it has to be consecutive. I just looked to the board secretary and the chair. I think that's correct. Yeah. So this is the rundown. So again, in terms of coming up with recommendations for convicted violators, we're linking it to the seriousness of the new offense. We're using our levels to simplify things. And then we have the ranges, and you can see the ranges vary a bit depending on whether the person was initially a violent offender or non-violent offender. And then we provide aggravating and mitigating ranges, just like for judges, so that they can individualize the circumstances before them. And then when we get down to murder 1 and 2, we would be including there basically the unserved balance. There wouldn't be, we just say, recommit for the unserved balance. So I think those are the key provisions we have for this. The only other thing I'll mention, and this goes to both technical violations and convicted violators, when we had public hearings, clearly there were a lot of concerns raised about number one, if someone's being revoked, there should be a real consideration about why is the person being revoked, and try to address that issue while you're recommitting someone. So we've talked to the board and with others about, how do we make sure that upon recommitment or during a revocation, there's every opportunity to try to do an evaluation or assessment, things like that, to try to figure out what it is that created the problem, and is there anything we can do during the recommitment to take advantage of that time. And I think it's sort of a mixed bag, and it depends on the circumstance of the cases, but I think there is an effort to do that, and we could just sort of promote that effort. The other thing is, we wrote into the text of these guidelines for both technical and convicted violators a real focus on thinking about the rehabilitative needs of the offender. You can't build that necessarily into these guidelines or these ranges, but you can say that one of the considerations is the clinical assessment of needs of the individual, that we think about drug dependence, we think about mental health issues and all those other kind of things that contribute to problems in the community. And we try to address those through this. And because we can't necessarily build them into the guidelines, we can at least build in language that says this should be part of that consideration, that it's not just the committing offense and it's not just the new offense, but it's also the needs of the offender that have to be considered when deciding what the recommitment time is and what the location is, and any conditions or any programming that the department looks at when the person's in their custody. So I think those are all really good issues. Final thing I'll mention, and this would possibly be a change to this, but we just spent time talking about murder 3, and I think we created a new category. So under this proposal, we would have included in murder 3 in category F, right? That's where we have the assignment for murder 3. So now we have a G. So I know how to add like one more row. But the question is, what should be the assignment for G? If we sort of follow the template here, we would just use the 48 to unserved balance and the 60 to unserved balance, unless we decided that effectively it should be treated like murder 1 and 2. But those clearly have sentences that are quite different than murder 3. So unless there's other ideas, what I'd suggest is we recapture this and we deal with murder 3 as we would with category F, that we give the same recommendations, but I'm open to any suggestions you have.
But just a separate question.
Sure.
And I think this was maybe what we were talking about
Okay.
earlier about the the recommitment, and then how can consideration be given to
Right.
the fact that there's both the recommitment range, but also due to their conviction violation, the person will be getting an OGS bump.
Right.
So I guess just like given that in that regard, we're now bumping it up in two separate categories. What consideration could be given to try to
So in this,
Figure out that.
these are, sort of two separate issues, right? So I think that the problem right now is individually, these might make sense. So the recommendations we give to the court for sentencing presently does not take into account as an aggravating factor that the person was under supervision at the time of the offense. We had talked previously about building that into the guidelines. So if someone was on probation or parole or bail and committed a crime, we would enhance the guidelines. But we declined to do that because we have these separate guidelines. So I think we've avoided like the double dipping, but I think the problem that's always existed, and I think we're like opening the door to try to figure out if we can improve on this, is to make sure that both sides know what the other side is doing, right? So I think by using a scale that judges have a better understanding of what the board may do or what's being recommended at the board, and that the board has a better understanding of what the judge might do in terms of the sentence recommendation, starts that conversation. But I think we could do more. I just don't think we can do more now until we, get this kind of thing in place and try to figure out, maybe it's through a change in the rules, maybe it's, something else that you can better coordinate that, because we should be thinking holistically about, the punishment or the intervention for this person based on these two different factors, instead of thinking of, it being a double hit or whatever else. We should be thinking about why we're doing what we're doing and thinking about it, about the person, and not about these two separate actions by two different parties. But we're not there yet, but I think this helps us start to get there. So first step.
Yes, helpful. Thank you.
Thank you. One final thing I'll mention, and this is just, keep in mind that there's a lot of stuff upstream from all of these things. There's been a lot of work by the board and by county probation and parole departments around the whole idea of how do you deal with individuals in the community that you avoid a revocation, that you're trying to not bring them back for those hearings or back for a revocation. And so there's a lot of screening efforts, a lot of treatment efforts to try to intervene early so that you don't have a failure on probation or parole. So this is always, remember, this is sort of like with sentencing guidelines, our starting point is a conviction offense. And with recommitment ranges, our starting point is a revocation of parole. So there's other things happening in the system to try to improve those stages and try to, divert people from being revoked. But this is when there is a revocation and the board decides to recommit, that we have some structures in place. But it doesn't mean this is the be all end all. There's a lot of other things, and a lot of commentators during public hearings talked about those concerns about whether it's drug dependency, drug use, whatever, mental health issues, about how do we make sure those people aren't caught up in a revocation? How do we try to deal with them effectively in the community? I know the board's doing a lot of work there. I know county probation and parole is. So, just wanted to provide that context. So with that, all I'll say is the materials that we've provided, I had an opportunity to discuss with some of the individuals of the board. They had a working group, which was incredibly helpful. And I got some really good comments, a lot of, technical comments on the definitions and just clarifying some of the language. So I have a lot of notes. And then, as I said, with just adjusting this to address the level G with murder 3. But otherwise, I think this is good to go, and we could do those modifications as staff edits. But I'm hoping that unless there's questions about this will then be the third document on the agenda in 7 minutes to approve for public hearings.
Any comments, questions, thoughts? Is there anything else? we
I don't
need to
know if
address?
the chair or the board secretary, because they've been actively involved in this process. Great, thank you.
And thank you so much for
Sure.
the collaboration and all the input. And I will say just as a, sitting on the bench, I understand these are just guidelines, but when I have people in front of me and they're like, I'm going to have a violation or I'm waiting on a hit and I have no idea. So I think it'll be very beneficial for the courts to at least have some concept of what we may be looking at in fashioning our sentence. So thank you very much. All right, with that, the policy meeting is adjourned and I'm going to give everybody until